Cancel. What are you doing?
I sent my link to Rita and then I promptly lost the Zoom meeting link. I don't know what happened to it. I had to get on my phone and resend it to myself. Odd.
Rita, you did not get it because I put you as an invite.
You did. And so what happened, I texted Julie. She sent it to me. I knew that I shouldn't use it because it was assigned to Julie. So I sent her an email and I said, when I searched it, I searched under Julie instead of you. And but it wasn't, I don't know why it didn't end up on my calendar. Because if I can't find it in my email, then I get it. Usually it's on my calendar, but anyway, I did have it. Thank you.
It was weird because I forwarded you the email, Rita, and then when I went back to my inbox, it was gone. It was still on my phone. I understand. Gremlins.
I'm sorry. Gremlins. It was my fault.
No.
So.
Looks like we're just missing one person. Is that right? Yeah.
Carson, maybe.
No, Carson's here.
He's here. I'm looking for Dave.
Dave is here.
Okay, how come it's not showing up?
I've got Colleen, Julie, Sonia, Kara, Carson, Dave Lewis, Monica, and Rita.
Odd. Okay.
It's everybody, isn't it?
It sure is. So I'll welcome everybody and call this regular meeting of the Code Enforcement Advisory Committee meeting on August 26, 2020 to order. So we'll go ahead and do with a roll call, please. I'll start. Julie Bowden.
Member Dickerson.
Member Johnson.
Member Strong.
Member Frangipani.
Carson.
Member Green, did you guys get that?
We can't hear you.
I think you just need
Sorry about that. You hear me now?
Yes.
Member Green.
And Rita and Dave?
Councilmember Russell?
Officer Dave Lewis, Code Enforcement Supervisor.
Thank you, everyone. I hope this finds all of you extremely well. Item number 2 on the agenda is consideration of the minutes from our previous meeting in July. Would someone please move to approve?
I move to approve.
A second?
I'll second.
Thank you. Any corrections or discussions?
Just one thing. Member Johnson, did you send the link to the video of the wood utilization thing?
Oh, no. I can look that up right now.
Cool. Yeah, I'm curious about it.
I think you sent it to me, and I thought you sent it to everybody. I'm sorry, Monica. I should have included that in our minutes.
That's okay. I will find it, and why don't I? Well, I think I have your email, Carson. But yeah, Julie, if I send it to you, can you put it in something?
Yes, we'll put it in the minutes, the link in the minutes for today. That way everyone has it.
Okay, Carson, I'll send it to you also right now, though. I just need to find it.
Cool, thanks.
Here.
I have a question or a correction or an addition. Under Communication Subcommittee update, I was directed to obtain the arborist list, which I did, but it's not mentioned here. And if Chair Bowden and Monica Johnson are happy with the way that's put, I have nothing else to add to that one. But I do think that since I was directed to obtain the list and I didn't send it to Chair Bowden, it did open up a lot of can of worms that I won't go into because it's an IT problem, but I would like that recorded. And just one other thing, I noticed that in past minutes, when CES Lewis made some salient points, that those were recorded in the minutes. And I think he did last time. He made some comments about process. And I just wondered why it's not noted this time. Because I think he was very clear and they were significant comments. And I'm just wondering why they aren't noted like they have been in the past.
Maureen, would you like to talk about the city council directive for our minutes in terms of action items and decisions?
That's it. City council has directed that the minutes are action minutes only. They don't include comments of any kind, only actions. If people want to know what the comments were done during the meeting, they can pull up the meeting and listen to the recording or the video.
Has there been any discussion of offering transcription then, since that can be automated and is so much easier to consume as a citizen?
No.
Yeah, that's frustrating to me as well. I miss the more thorough minutes that we used to have from the board I was on before.
I also wanted to thank you, Colleen, for identifying that action item. We lost the last 45 minutes of audio from our meeting in July. So I was operating off of memory and I had forgotten about that request. So thank you for pointing that out.
Loss? How would that have happened?
I don't know.
That happened because, first off, as a backup, we usually use this tape recorder. Okay, it ran out of batteries and I didn't have any with me. And then secondly, for some reason, and I don't know why, but the video recording quit about, it was maybe, it wasn't, I don't think it was 45 minutes, but it was a while.
Yeah.
So yeah, it was just technical glitches that occurred.
Yeah, and several of us lost internet and were
Oh, that's
disconnected for a while too.
That's right.
Yeah.
That happened to myself and Julie.
Yes.
And so
Colleen. Yep.
Colleen, yeah.
So it's probably related to that, the internet, something happened there. Because that's right, I had forgotten. I was kicked off and unable to get on for a while. Okay, were there any other amendments to the minutes from July? Okay, is there a motion and a second to approve the minutes as amended? No?
They've been just motion to approve, so yeah.
Yeah, I modify my motion to include what Member Dickerson pointed out about, I do think that it's valid to have salient points included in the minutes, especially when we've taken the time to discuss it and received direction from Mr. Lewis. I think it's unreasonable to expect that citizens have to watch multiple hour-long recordings that are, as not even often not very easy to listen to, and are now, as we know, sometimes not even all intact, and having a record accurately reflect valuable details to me seems important.
Can I add something to that? I understand from, and perhaps this is directed towards our council liaison. I understood when they were discussing policy that it's built into their policy that while the minutes are action item only, they have the right to have included a narrative as to why they voted the way they did.
I believe that is correct. If a council member asks that something be put in the record, I do think that is put in the record. I have made a note of some of the suggestions. I will bring that up at City Council, especially the fact that transcription can be automated. So, I mean, you should be able to search it also, right?
Absolutely. Yeah, there's a technology, I mean, there's several of them, but Otter is one to look at. I've seen that it's extremely effective. Just from a friend who uses it to record meetings at Metro, and it identifies the speaker in the transcription automatically. There's no reason that the city couldn't do that.
Maureen?
Just as a reminder, transcriptions of a meeting are not minutes and never have been. It's a completely separate thing that you're doing. Minutes can include points that are important, like directions and stuff like that, and definitely the action item, but a full transcription of a meeting is not minutes. It's actually a transcription of the meeting.
Yeah, I get that, but you're posting the recording of the meeting. What I'm saying is alongside the recording of the meeting, which is very difficult to consume and is unsearchable, include the transcription. And I think that should be policy across the board for the city, because that's far more close to true transparency.
If I can circle back to the amendment that Colleen had, that we had directed her to contact the city regarding the list of arborists and reordering that list, so that I believe that was the request, right, Colleen?
Yeah, but they had already done it. It was separated by city. But if you want me to go into it, I did ask some further questions, and there was a problem with what they defined as arborist. It's very confusing, and I'd like it put on the agenda so I can address the issues.
Okay, so for the purposes of the minutes, I think the amendment is that Colleen was directed to contact the city about reordering the list of arborists to list the Inglewood-based businesses first, which I thought was a great idea, and I'm glad to hear that the city was able to accomplish that.
Not really. They're not first, but they are separated by city.
Okay.
So
Colleen, let's go ahead and finish the minutes. And then in terms of a motion to add an agenda item, do we do that later on, Maureen? Okay, all right.
And then I just want to finish this subject, since we're now making it to where the minutes, we're continuing to go forward with this city council guidance of such limited, non-informative as to what the meeting includes minutes, then I think we should all take into account that, let's all, as things come up that seems salient, that would be nice to have the citizens be able to consume in the minutes, let's make sure this is recorded. I'm going to try to remember that.
What you actually, sorry.
Maureen?
What you actually need to say is, I would like this statement included in the minutes. You actually have to say that, and then they can be included in the minutes.
Okay, thank you.
And just for the committee's understanding, in the past, we did have detailed minutes. And what happened is it took the chairman hours to do the minutes, because you had to re-listen to the entire meeting and verify everything that was said. And then if someone didn't agree with the interpretation, then we would take up to an hour of our meeting correcting the minutes. And so we were relieved to move to this new format, because this allowed us to focus on the business at hand and not get into the administrative challenges of doing minutes.
And Chair Bowden, that totally makes sense. I don't want any, volunteer chair of a committee to be, forced into doing that, honestly, it's, unfair and unreasonable based on what's available technology task, which could be alleviated by utilizing current technology to automate a full transcription that's searchable and provides a better outcome for citizen transparency.
Duly noted. Thank you. So again, the only amendment we have on the table right now is to add the directive for Colleen to contact the city regarding the list of arborists. Were there any other amendments to the minutes?
I modify my motion to fit what you just said.
And I modify my second to second it.
Okay, so please vote by a show of hands. Those in favor of approving the minutes as amended? It looks, Cara, we can't see you, so,
I'm raising my hand.
okay. So that's unanimous, Maureen. Thank you. The minutes as amended are accepted. The next item on the agenda is the public forum. Maureen, do we have anybody?
No, there's no attendees.
Okay. Kind of missed that aspect of it, right? Okay, next on the agenda is recognizing our representative from Code Enforcement Supervisor, Dave Lewis.
So if you've reviewed the statistics from July, you'll see that we've continued to increase our weeds enforcement. We're still behind on reactive, but we have significantly increased our proactive enforcement. And as I mentioned, we did hire the seasonal code enforcement officer that is doing a 24-week alley by alley inspection of all overgrowth of the city. So we've made some significant strides in that area. Just to carry that point over, I'd like to let you know that we typically have roughly 400 to 450 average cases per month. This month we have been, and you'll see statistics next month, but we have been very busy here in code enforcement, and we just hit 1,030 cases for this month.
For this month?
For August, and we're not even finished with August. Keeping with reporting on trends, you'll also see that there's an increase in animal control cases that were open. That's been primarily as a result of the proactive enforcement that we've been conducting within the parks. As well as you'll see some things that we believe are related to COVID and some of the financial consequences that we're seeing, specifically with trash and litter. You'll notice that we have a significant increase in trash and litter complaints this month of cases that are open. We're just finding that people are not having their trash removed in a timely manner. They've opted for every other week trash services, so it's really causing more of a pileup, or they've had trash services canceled. We're also seeing outdoor storage concerns. We're continuing to, we've laid off on a lot of our parking enforcement or parking complaints within our department. We primarily would look at expired plates and stuff. Right now we're issuing more warnings just because the Department of Revenue, if it's within the last 3 months, is still not operating to full function to allow for proper registration. But we are seeing an increase in parking associated with RVs. We are seeing more RVs in the city. We are seeing more complaints with RVs, people living in RVs. And again, I believe this is as a result in having conversations with some of the violations as a result of COVID, where people may have lost their housing. They've been invited to live on a person's property in an RV. And the number one contributing factor is the current state of some of the economic affairs within the state and the country, and specifically related to COVID shutdown.
Okay. Carson?
What technically is an RV? Is that any vehicle that someone could sleep in? Like, is a big van without anything special on the outside an RV, or is it only like a vehicle that was built to be an RV?
It would, in this category, it would be both. You are prohibited from sleeping in a vehicle. The way we classify an RV is any recreational vehicle, those that are designed specifically for use that would include cooking, sleeping, overnight accommodations. A van can be not just a van can be classified as a recreational vehicle because it is equipped with cooking and sleeping, as well as a trailer. Trailer RVs may not have an engine, however, they are equipped with cooking equipment, living facilities to include potential showers and toilets, as well as beds.
And it sounds like there's kind of a mix of how, like, I mean, it makes sense. A lot of people are getting pushed out of their housing. There's a whole bunch of horrible stuff going on. So is the not sleeping in vehicles being strictly enforced, or?
It's not. We are taking an educational approach. We are letting people know this is prohibited in the city of Inglewood. We are referring them to specific campgrounds or those campgrounds that are providing spaces at low cost if that's the situation. We are not the only city seeing this. This is a metro-wide area concern. We are seeing it significantly in Denver. They are now switching to their enforcement mode, where they have changed from education to enforcement, and that, I believe, it started in the last week. We may see potential of those people coming into Inglewood thinking that, you know, they'll pack up and they'll sleep in a park, or they'll be adjacent to an area. Walmart has also is no longer permitting people to camp inside of their vehicles on their private property. And they're letting people know that as well. So it's more of an educational approach that we're taking versus a strict enforcement. And we're really allowing those folks 24 hours, in some circumstances a little longer. We're also partnering with our All Health Network if needed, where certain resources can be provided, whether it be mental health services to resources related to domestic violence. There's not one answer to fit this, because it is a multifaceted, complex issue.
Do you know if, like, all the adjacent cities also have no sleeping in vehicle code?
From my understanding, a majority of them do, or they have enacted them recently within the last couple years. Denver being the most significant in the recent adjustments. I think they changed their ordinance last year.
Colleen?
Yeah, to follow up on what Carson's been talking about, what code are you using about not sleeping in vehicles?
So that specifically would fall under the building department, and I'm not able to access those codes right now to list that for you. But it is prohibited to park an RV, specifically for the parking codes, and that specifically to park an RV in the city of Inglewood on a public street for more than 72 hours that is not being expeditiously loaded or unloaded.
Yeah, isn't that in the vehicle code though, the model vehicle code? Title 11?
Yes, but there's also a zoning code pertaining to living in a motor vehicle.
Okay.
Further questions for Supervisor Lewis? Colleen?
Yeah, trying to get it on the record from what, you know, the salient points that Mr. Lewis, Code Enforcement Supervisor Lewis had last meeting, and I'd like this on the record if we can do that. Under what circumstances do you go straight to posting notices or summons and complaints?
If it's possible, I'm not prepared to have that conversation and have access to my notes or codes. I would really like that, if possible, to have a more in-depth conversation about that, because it is directly outlined specifically in the code, the steps that we take.
Well, yeah, I know. It's just that the last time you said that there were circumstances that would allow you to bypass the process. And so I was just trying to follow up on that to get it on the record, because I thought it was a good point you made, and I would like more information about it.
I'm just seeking the direction of the chair if you'd like me to have a conversation about this.
Well, we've always had, we've always gotten direction from all the liaisons that the process had to be followed, and it was a multi-step. Post notice of violation with a certain time period, posting.
Well, the typical process is.
Excuse me. I don't know what am I putting this whole conversation on the record? Because
Yeah,
No,
I'm not sure.
I just want the question and an answer.
So the typical process would be a 7-day notice of violation, followed by a 14-day official posting notice. These are guidelines that are set out within the municipal ordinance. Occasionally, it does take longer. We do extend some of those posting or notices to gain voluntary compliance. We will typically skip the notice of violation if this is a repeat habitual property, and we typically would add nuisance to that violation because we are able to articulate the ongoing concerns of non-compliance at a property. And if we're unable to gain that compliance, then we move that forward to summons. If it is an ongoing problem within the city of Inglewood, we do have a nuisance abatement team. It is a organizational team from within the city that does include the city attorney's office, the prosecutor's office. It includes command staff, police officers, includes people from public works, zoning, community development. We all meet to staff specific cases and specific properties.
Okay, so to say it briefly, if there's frequent violation, you can skip the notice of violation and go straight to the posting notice.
Correct.
Okay, that's what I want on the.
Got it. Thank you, both of you, for clarifying that. Carson?
I have a question about how does a dog become designated dangerous?
That is strictly through the court. The city files a report with the prosecutor's office along with the summons. The summons would indicate the violation that occurred, and a court would adjudicate that animal as dangerous. And so that is strictly left to the court system.
So for a citizen who has been attacked by a dog that jumped out of someone's yard and bit them and actually broke their hand, what do they have to do to get that dog to go through, or to go through that process for the courts, especially if like it was reported to an officer? And I'm not sure if this was a code, like so I saw something on Nextdoor, a report about a woman who got attacked and her hand bit and a bone broken, and saying that, you know, she went to law enforcement and they did nothing. And I wrote to her and suggested that she come on I told her I wasn't representing our committee or anything, but just as a citizen, you know, I care that sounds pretty bad. And we do have dangerous dog protection, but I'm not super clear on what the process is. And I suggested she come on to our meeting as a citizen and ask. So I'm going to just ask, and I would like this on the record as well, the details of the answer.
So Carson, I respectfully need to decline answering this answer at this time. This is a current ongoing case that is currently within the court system.
Well, then just answer from the perspective of not this case. When someone's attacked by a dog, what is the process? Should they call law enforcement? Should they call code enforcement? And then how does it get in the court?
So first and foremost, if somebody is bitten by a dog, whether it's another dog or a person, they should immediately call 911. That will start the process to have, number one, some type of an officer respond. If it is after hours, it will always be a police officer that will respond. If during when code enforcement is on duty, they will also respond. A report is generated, and based on the totality of the circumstances, because there are specific exceptions within the ordinance, a summons is issued and it moves forward through the court system.
And then only if it makes it all the way through the courts and a judge. So what would the judge has to rule that it's a dangerous dog, or how does that work exactly?
That is correct.
And then all the rules around protecting and monitoring and tracking the dangerous dog kick in.
That is correct.
Do you have any perspective on how many designated dangerous dogs there are in the city right now?
Are we still including all of this? Where are we
Yes,
stopping?
please.
Okay.
I think this is all relevant information for citizens that they shouldn't have to watch a long video to hear.
Yeah, I'm not prepared to answer any statistics related to the number of dangerous dogs, because It's specifically set by the courts. I believe the last possible count was around 9.
Thank you very much, Officer Lewis.
Colleen?
Yeah, on the animal control number 147, and I know I've asked this before, but I thought I'd give it a try again because I wanted to bring up some information that went to council. Do you know how many summons and complaints were issued on animal control issues for them?
I'm not able to answer that question.
Okay. Who gave the city attorney the information that she supplied to the council on council request CRT 0141 dated July 24th, 2020? The subject was, what are the number of dog cases that go to trial versus the number that pay a fine? And the response was, during the past 12 months, there have been no cases involving dogs that have gone to trial. But I think I have to question that. Over the same period of time, there have been 108 cases filed in the municipal court that involve dogs, with charges ranging from lack of vaccination to running at large, dangerous behavior prohibited, tag and collar, cruelty and neglect, number of animals, and at-risk behavior. Can we get this information? And who gave it to the city attorney to present as a response to this case? And how can we get this information on a monthly basis?
You'll need to ask the city attorney for that information. That document was prepared by them. It was not provided by anything within the police or the code enforcement division. The court runs independently of the code enforcement division. So that is a request you'll need to make of her.
Okay. I would like that statement put on the record, please.
Well,
Further?
just as a clarification, if you guys want a statement placed on the record, you need to say, the statement I'm going to make, I'd like to be put on the record.
Okay, the
Because when you
statement
say
I'm
it
just now
after-
going to make.
Wait, I'm still talking. When you say it after the fact, then I have to go back and re-listen when I don't have to if you say it in the beginning.
Well, I'm going to summarize it right now. I would like it put on the record what Dave Lewis just said, that information about summons and complaints are only available through the court.
And I'm gonna let you know that more than likely summons and complaints, he did not say that. What he said was that the report that you're referencing from July did not come from his office, which is correct. It came out of the courts. I'm sure that the information that was received and presented to City Council came from the municipal court. And just because there was 108 summons doesn't mean that any of them went through trial.
Well, I happen to know for a fact that 2 did. But
So then I need you to restate exactly what you want put in the record, because I've got everything down here up to the point where Dave said that he believes there are 9 dogs that have been deemed dangerous in the city of Inglewood.
that are still
What do you
classified.
want in the minutes?
I want whatever he said, that the information about summons and complaints did not come from his office,
Okay.
but we'd have to contact the city attorney to get the information.
Further questions for Supervisor Lewis? Monica?
I'm gonna parse my words here. Officer Lewis, I think that, you are trying to keep our community safe and citing these incidents, and sometimes they get passed along to the court. Is it not true that the litigants involved are responsible for taking these issues to court at times?
So you have to look at two components here, and this is getting very complicated in the discussion because there's two parts. There's the criminal municipal portion. There's also the civil portion.
Okay.
And so my responsibility, or the code enforcement or police responsibility, is to gather the evidence, collect the information, issue the summons, and pass it on to the court. We are not always the witnesses in specific cases. For example, we may arrive on scene after a bite has occurred. And so we're relying on witness statements, just like any other crime, to take this specific charge to a reasonable doubt to the court system. So, for example, myself, if I was to respond to an animal bite, and I took the report, I gathered the witness statement, I'm only able to testify to what I observed or was a part of. Anything that happened would be considered hearsay. I couldn't say, this person told me the following. The victim or the witnesses would also need to testify in order to support that criminal charge. Not all cases go to trial, and I know this was not asked, I know this is where Colleen was going. There are things that take place within our criminal justice system, regardless of what the charge is, that take place leading up to a trial. And most cases, and I don't know the statistic, but it's very high, in the high 90s, never make it to trial because there's compliance that is gathered, there are plea bargains that are arranged, there are penalties that are imposed, and these are conversations that are outlined and the judge accepts and then moves forward with a guilty or not guilty plea.
Great. Thank you for clarifying that. And the reason why I bring it up is that I just think I feel like sometimes we're bringing up specific instances, and I don't know what the proper procedure for following up on those are, but I don't know if this is the place to do that. And also, it sounds like you're doing your part of the job, and I feel like it's our job as the committee to support you in that. So I just wanted to share that with the group, that I feel like that's what our mission is here. That's my understanding of it anyhow. So that's all I wanted to say. I know.
Thank you, Monica. Carson.
Well, just in regard to that, like, that's the first time I've ever brought up a specific instance. And the reason I did is because I know we have it on our agenda to address the dangerous dog code. And if there's things about the way it's structured that are making it difficult for someone who got bit to, be able to have an outcome of that dog becoming a dangerous dog, then I think it is worth our consideration. My interest is in the process.
Yeah, there's, Carson, we've spent a little bit of time with that, with Colleen Moore, did quite a bit of research, and what we found was that the code for dangerous dog, is pretty solid. We just haven't provided a lot of the tactics that are supposed to be used. For example, the dog is supposed to be identified in a very obvious way that they're a dangerous dog. And so we came up with some solutions in terms of collars that people would recognize that the dog was being identified as dangerous. So
yeah, that's what I'm referring to. I was part of that discussion, like at the end, after you guys had done the work, then I joined, and then we talked about all that stuff. And then I know it's been moved in the agenda, but that's why I was interested.
Yeah. Supervisor Lewis?
I really just want to clarify something. Carson did touch on something. I want to assure this committee and council and anybody that's listening, this division within the police department, as well as the police department, take the health and safety of our community very serious. We do act upon these situations in a professional, objective manner, and we evaluate the entire totality of the circumstances and do present a very thorough criminal case that does go through to prosecution. So please, when you hear things, I know people get frustrated with the process, but having a dangerous dog is a municipal criminal charge. And somebody charged with that is entitled to everything that the law affords under the Constitution, the state, and municipal code for that prosecution. So not only do we need to protect the rights of the victim, we also are bound to protect the rights of a subject. And this goes for all criminal charges that move forward. And it's important to note that all code violations in the city of Inglewood are municipal criminal violations. We do not have administrative violations in the city of Inglewood, which is why people become somewhat frustrated, because the process does go through the court systems if needed, and it is a long process at times. So we do have to afford those constitutional given rights to our citizens, subjects, victims, anybody that is involved in a case.
Thank you. And I don't disagree with anything you're saying, and I appreciate the work you guys do. And I wasn't trying to imply any questioning about whether you guys were doing it right. For me, it was more trying to understand what it is and how it works, so that, you know, when we're discussing, because I know dangerous dogs is still something we haven't completed. And so understanding that process, especially when I did see something that implied that, you know, they were frustrated with the process, wanting to know it, because we are supposed to look at these things. And if there are improvements to make in the code, then we are supposed to make recommendations. And that is one that's on our agenda. But I apologize if it came across like I was suggesting you're not doing a good job taking care of citizens.
No, I didn't take it that way. I just really wanted to clarify so that everybody that's listening understands that we do take this serious. We are the highest trained professionals in the state of Colorado. We are 5 of 89 statewide agents with the Department of Agriculture, Bureau of Animal Protection. So we do take this very serious, and I just want you all to know how serious that we take these situations.
And Carson, too, the the code really doesn't help a dog that had not been previously identified as dangerous. So in this case that you're referring to, I don't think the dog had been identified as dangerous. It became dangerous and is now being addressed, I'm hoping. But so the code really only helps after it's been identified as dangerous versus before.
Right. Yeah, I understand.
Okay. Further questions for Supervisor Lewis? I actually have a follow-up question. At our last meeting, we talked about dogs on leash or off leash at various parks, and we were trying to decide what our role was. And then we learned about the task force that the Parks and Rec, I think, committee is looking at that, and we had talked about checking with them to see if we could have someone from code enforcement be a part of that task force.
Yes. So Member Johnson is a part of not only this committee, but she's also a member of the Parks and Recreation Committee. And at the last Parks and Recreation Committee, they did approve to move forward with a subcommittee. Not really a task force, it's a subcommittee of that organization. And I believe Monica, and she may need to speak to this more, Monica may have been asked to participate not only as a parks person, but also a representative of this particular body.
I did attend that meeting, Officer Lewis, and to my understanding, it was my first meeting with them, and they were talking about reconfiguring this task force that they had made. And I was just listening at that point, and at the end of the meeting, I offered to participate in that and mentioned that we had spoken about this on our committee. But I thought it was like a task force, and it had citizens on it. So I am not directly involved in that at this point, but I can reach out to their, or at the next meeting.
I think they're still evaluating that process. I think it was just approved.
Yeah,
I believe that the Parks Director may have said, oh, this would be a great opportunity. I think she was approached that Member Johnson, and she's in both committees, would be an excellent representative and conduit. It just seemed more natural, I think, was more of the, when we had that conversation.
Yeah, and I'd made that clear that I would be interested in doing that. So hopefully we'll do that moving forward.
Thank you for agreeing to operate in that role, Monica. We appreciate it.
Mm-hmm.
All right. So no further questions for Supervisor Lewis. We'll go ahead and move to our next agenda item with our update from City Council Liaison, Rita Russell.
Thank you. I'm not sure I have very much of an update. You know, actually, I was on vacation last week, and I enjoyed vacation so much it was kind of difficult to come back. But I do appreciate everything that you're doing, and I am taking notes because I think there's been some very good things in the discussion tonight that council should be considering. And so was there anything specific I was supposed to check on?
I don't think so, unless anyone has a specific question for Councilmember Russell. Okay, thank you, Rita. We'll move on to agenda item number 6, which is the Communications Subcommittee in regards to any reports or updates. I can go ahead and go first. We did complete both of the articles for Emerald Ash Borer and alley maintenance. How quickly we forget. And I believe, and that we made the deadline. I don't think it's coming out until the beginning of October, so it'll be a couple of weeks. And another topic is I've been operating as head of the Communications Subcommittee for the past 2 years, and I'm doing it at the same time that I'm chair of this committee, and I would like to step down as the Communications Subcommittee lead and offer that position to another person on the committee that would like to be involved in that. So at this point, with me stepping down, Colleen, member Dickerson, and member Johnson are the 2 people that are in the Communications Subcommittee, and I'm asking if there's anybody else that would like to participate. And then of those people that are on the Communications Subcommittee, we'll need a lead in order, one person needs to interact with the city and with code enforcement in terms of the content.
Hey, Julie, can you hear me? This is Cara.
Yes.
Hi, I'm willing to volunteer for that as well, so.
Okay, thank you. Thank you very much.
I just
Colleen?
wanted to say something. In our bylaws, and actually in the code, the chair determines the people on the committee, the subcommittee, and sets their agenda. So
Okay.
it's up to
Okay.
you. You don't have to ask for volunteers. You can just assign.
Well, I want to get people involved that want to be involved, and it sounds like Cara has stepped up to the plate. Monica?
Did you say you need someone to be the lead on that?
We do,
Okay.
because there needs.
I'd be happy to.
Thank you, Monica. So will you please put that in the record, Maureen, that Monica will be the leader for the Communications Subcommittee, and that Cara has agreed to fill the empty position that I just vacated. And the reason why it's important to have a leader is we need one point of contact with the city and code enforcement. It gets really confusing. But Monica, why don't you and I sit down? I can share with you the steps that I've taken. Number one, to understand what the priorities are with code enforcement, and then we propose topics to the committee. The committee decides what the next topic will be, and then you work with code enforcement to draft the article, and then run it through approvals with the committee, and then send it to the city. So I'll sit down with you separately to go through that process with you.
Excellent. And you can also review with me proper procedures for communication.
Sure, will do.
Thank you very much.
Will do, and thank you all for agreeing to do that. I've really enjoyed being a part of the Communications Subcommittee. When we first got into it, we didn't have a communications lead at the city, and there were no plans to regularly communicate code to the residents. So the committee stepped up. This committee stepped up and said that they would be happy to provide that material, and we have just continued to do that. We now, of course, have Chris Harguth, who leads the communications group at the city, and he did offer that if we did not want to do that anymore, his staff is willing and able to take up the role and moving forward. He said, but it seems like this committee is really effective at communicating code, and our writing style matches the city. So it's a fairly seamless process. And by the time we get the article in, we've had everyone review it and approve it. And so it's pretty solid. Any further updates from the communications subcommittee?
Unless you want me to talk about what I found the city is doing with arborists.
Actually, why don't we do that as the next agenda item, Colleen, for
Okay.
new business? We don't have an agenda item for new business, so why don't we add?
We could put it off until next month because I didn't really develop the materials for it. I just, I'd have to review what came in from via email, but I can summarize it if you want to, if you just want me to summarize it right now.
Yeah, and I just want to make sure that we stay on task with our priorities. I know that we had asked, to have that list reordered, and in doing so, you learned some additional things, but I'm not sure how it relates to the priorities.
It relates to trees and shrubs.
Okay, thank you. Okay.
And what constitutes an arborist and the licensing thereof. So.
Okay, so why don't we include that in our, when we get to trees and shrubs, we put that as an additional topic to cover. Thank you.
I will send some, I'll send some of it to you to include with the agenda package.
Okay, okay. All right, so the next agenda item is unfinished business. And the first topic is our bylaws update. And for the benefit of our newer members, our bylaws are the rules that this committee decides how we want to operate. It's up to us to decide what those bylaws are. And the bylaws that we have had have not been updated. And we just recently updated the enabling legislation for this committee that will impact our bylaws. So because we needed to go back and look at our bylaws anyway, we're looking at the whole document to incorporate the changes from enabling legislation and see if there's anything else that we wanted to include. All right, so and this has been, I think it's been 2 months now, 2 or 3 months. So what we did is everybody on the committee at the time was able to review the existing bylaws and provide their comments, and we consolidated all the comments into one document. And then at our May meeting, we started reviewing the bylaws and got about halfway through it. So in your agenda packet, if you will, on page 7 of 29, is a draft. It's called Draft from June 17 meeting. Can everybody pull that up? Because it gets pretty complicated, so I want to make sure. Actually, I'm going to share my screen. Share screen. All right. All right.
Hey, Chair Bowden, the version that wound up in here, that's after all of our edits, except not including what Member Dickerson just sent today. Is that right?
So it's the draft from June 17 meetings. The first 3.5 pages is what we covered at our last meeting, and we were able to reach agreement on the edits that we wanted to have made. So, so anyway, my thinking was that we would pick up where we left off.
Julie?
Yes.
When I went through this, I noted that it wasn't quite the same, and that I had you know, that there were some problems with the code itself. It's pretty easy to go through, but like under, if you want me to, I can go through it and just note the problems and then decide if we want to deal with it. The most important is that under section 3 purpose on page 7, it used to have it the correct way, but on the second line, it now says activities and services of code enforcement. That's not the wording in the ordinance. It's activities, comma, strike and, services, and regulatory processes. So we have to strike of code enforcement and strike and put a comma in after activities. And it was fine before. I don't know how it got changed, but that's one thing. Another thing in section 2, the committee was actually established in 1985. And I don't know if you want to add that. And under powers and duties, A, somehow and ongoing and is not in the original language, so it needs to be changed. Conduct a comprehensive review. Down on C, I know this was struck through at some point, but the first sentence is old language. It doesn't belong there. The second sentence is what's in the code. The third sentence is not there. And the fourth sentence is in the code. So somehow that didn't get, and I don't know how, it might be my fault, but that's the first sentence that says the committee shall establish enforcement priorities. That's not in the code. And make recommendations to the city manager for adjustments to city staff. That's not in the code. So that has to be struck. And then there are a couple of other items on D. So that would be page 9. On the fourth, well, right after the third line where it says city council and as needed on the fourth line, that's not what's in the code. It says for service delivery. So as needed needs to be replaced with for service delivery.
When you say that it's not what's in the code, what are you referring to?
I'm referring to 2-10-1 through whatever it is, the Code Enforcement Advisory Committee, enabling legislation.
The changes that were just enacted.
Yes, the changes that were just enacted. Somehow the wording is not quite correct.
You're gonna, you went through a lot of those very quickly. Can you please start at the beginning?
Yes. Section 2 creation, do we want to add the actual start date, which was 1985?
I don't know. Do we? Is there a reason that we want to add that?
Well, we've got everything else in there. We should know when it actually started. But that's up to the committee. I just noted that it didn't start at the right date.
It sounds like it reads here that it was adopted in 1997.
No, it was adopted in 1985 according to the code. It's got it right there. It's got it right in the code that it was 1985.
When you say it's in the code, what are you referring to?
At the bottom of it, it says code 1985. And then there's a note that the 1985 editor's note, it says the change, former section 2-10-7 pertained to a sunset provision and derived from the Code of 1985. So it started in 1985.
So where are you seeing that again?
In the municipal code, under general rules, it has an editor's note. No, it's actually at the end of the whole section. Editor's note, ordinance number 00-9, adopted March 6, 2000, repealed a certain section. Former section pertained to the sunset provision and derived from the Code of 1985. 1985 is noted under each section as when the code was, when the code started, and where the language came from.
Okay, so I'm looking at the ordinance for Title II, Chapter 10. It's not, what you're referring to is not in that document. Is that correct?
No, it's in municipal code. It says under 2-10-1 purpose, Code 1985, and then ordinance, yeah, apparently it didn't change.
Chair Bowden, what she's talking about is the published municipal code at, library.municode.com, and each section in the code references, I am guessing that references the original version of the code that it existed in, and then probably something about when it was updated. So I see that reference to Code 1985, but I don't, I'm not sure exactly what that means. Are you sure that's what that means, Member Dickerson?
Yep. I'm not saying that it's accurate, but that's what it means. All through the code, it says when it started, and it should say when it was revised. I just noted it, and we don't have to do it. It's up to the committee, but I think it's important that we know that it started 12 years before this says it was created.
But you're assuming that you just mentioned that you're not sure that that's accurate, because
in some cases, it hasn't been accurate. I believe Member Green told us that he found it wasn't. But this has been there ever since I've been on the committee, and it's been there ever since I've been paying attention to code.
Yeah, and just to clarify what she means by what I found wasn't right, was what I had noticed is that the municipal code, this municode.com service that Inglewood utilizes, has the ability for anybody to sign up to get notifications for any changes to the code, and that wasn't working right. And City Council Member Russell brought that up and got that fixed, and that has since been working correctly. But it wasn't about, at least what I reported, wasn't about code being inaccurately referenced in the municode.com library, but just that the updates were not accurately reflected in the list of updates and in the notifications made available.
Well, sorry, I hope I'm not making you guys sick. So I've pulled up the quote code that you were referring to. It's Chapter 10, and what you're referring to is this line here that says Code 1985.
Correct.
But we don't know what that is.
We do know that that means that the code for the Code Enforcement Advisory Committee existed in 1985.
Okay, well, I'm going to leave it up to the rest of the committee to decide if you think that's an important thing to include in our bylaws. I'm not comfortable that we have the full details behind it, because I'm pretty sure the bylaws and the enabling legislation are accurate, I don't know why there's a gap between 1985 and 1997, but to assume that that's that we started in 1985, I think is a mistake. We don't know that for sure.
The only
Yeah.
mistake would be that they didn't put in the reference to changes in 1997.
It could be that 1985 applies to everything that existed prior to when the municipal code went into this system. Because if you look at like what available updates there are, they only go back to like 2016. This hasn't existed since 85. So that may have been a blanket thing, and only updates since 2016 are accurately reflected. So, I mean, I think it's interesting. It seems like one or the other should accurately reflect, you know, when it was created. I mean, just for posterity and interest. And I don't know that the bylaws are wrong, or that what's in code is, I wouldn't call that wrong, but anyway, that's my 2 cents.
Well, I'm looking at the Code Enforcement Advisory Committee, Chapter 10, and nowhere does it say this committee was established in 1985.
Or 97, right?
What we have from 97 was the enabling legislation, but I'm not seeing any, I mean, other than the fact that it keeps going down.
Well, it does say it was derived from the code of 1985.
So I'm not comfortable putting it in until we confirm that that is indeed the case.
That's
Other
fine.
committee-
You want me to
Yeah,
go on to
definitely agree.
the other issues?
Well, can I please finish this? Other committee members, do you have any input beyond what we've just discussed? I mean, if somebody wants to do the research and determine if the accurate date that we were started, whether it was 85 or 97, I'm fine with that. But until we have that fact verified, I don't think we should put it in.
Yeah, Julie, this is Cara. I agree with you on that.
Okay, thank you. Okay, Colleen, can you please go to your next comment? And by the way, so we had 5 committee members that reviewed the bylaws, and we combined all of our comments into one document. So it's not surprising that not all the edits were caught or accurately represented. So I appreciate you, Colleen, going back through and verifying these. Can you point to the next one?
Yeah, section 3, purpose. On the 3rd line, well, it starts on the 2nd line, of code enforcement. That's not in purpose.
Yeah,
It says,
actually, in the version that I had edited and sent to you, Chair Bowden, I had actually made a note and commented and corrected it to what was in the code, which is exactly what Member Dickerson is saying, except I think you even left out one of the commas, Member Dickerson, because it's supposed to be activities,
yes, you're
comma,
right. I did. I
services,
just
comma.
noticed it. The problem was that the document we had that combined everything, it was correct on purpose, but somehow it fell off, and of code enforcement was added in there before and regulatory processes. So it should read activities, comma, services, comma, according to this, where I lost it, and regulatory processes. So it needs to take out one and, add a comma, and take out of code enforcement to be accurate.
Well, and a comma after services if it's going to match, assuming we want the purpose in the bylaws to match what's in the code.
And I think we have to.
So can you read it again, please?
Okay. The Code Enforcement Advisory Committee is established as an advisory committee to the City Council to regularly review the activities, comma, services, comma, and regulatory processes established within those sections of the Inglewood Municipal Code enforced by the Code Enforcement Unit of the Police Department, and to provide recommendations to the City Council for updates and modification to those services and regulatory processes.
Great, thank you. Did everyone get that? I got it. Okay.
The next one is A, and it's real short. Somehow, and ongoing and comprehensive review. We need to take out an, ongoing, and just replace it with A.
And that's based on,
The code itself, conduct a comprehensive review. Not conduct an ongoing and comprehensive review.
so why would we want to take out ongoing?
Because it's not in the code.
But the bylaws are ours, so we can decide.
Yes, but that we have to have the code exactly as it is, and then we say what we want to do with that code. How, what guidelines we're going to do. So I think it's incumbent upon us to be exactly what we are allowed to do per code.
I get that, but I like the ongoing and comprehensive review, those two words.
Well, it would be nice if, we could put that in guidelines of how we want to operate. But as far as the recitation of the code, I think it needs to be exact wording. It's always been that way. All our bylaws have always had it exactly the way it's written in the code.
Okay, so that was a proposal by somebody on the committee, I don't know who, that we conduct an ongoing and comprehensive review versus just conduct a review. The reason I like the ongoing and comprehensive is it implies that it's something that we don't do one time. It's more something that we do all the time and we keep an eye on it.
And I think that should go in guidelines on how we conduct our responsibilities. But I'm not taking out comprehensive. The code has it. Conduct a comprehensive review.
Again, what is the problem with saying an ongoing?
It's not in the code.
But it doesn't have to be in the code. This is us putting our bylaws together saying that we wanted to do ongoing. Monica.
Is there somebody on this meeting that can clarify whether it has to match the code or not?
It always has, and it seems to me that we can't tinker with the code. They changed it for a reason.
Okay, I get your point, but does somebody know this definitively so we can move on?
So I think, can I respond to that?
Yes.
Chair Bell?
Oh, sorry.
I think that is a question that probably should be asked of the city attorney's office, which means the recording secretary is in that office, so I think she could get the answer to that question.
Do you want me to answer the question?
Yes, please, Maureen.
Okay. The code you cannot tinker with. The code is law, basically. The code is approved by the city council and is part of the municipal code, which makes it go into law. So you cannot tinker with the code. Your bylaws are your operating procedures. Bylaws are supposed to tell you how you're going to operate. It's a completely separate entity that that you guys review and you guys make up your bylaws. If you're going to include code, you don't have to. If you're going to include code, you do have to actually have the codes in there saying what they say now, because you can't change code. But you don't have to have codes in your bylaws. Your bylaws are your operating procedures. If you want to reference code saying code says that we are going to do this, that, and the other, you can do that. You don't have to.
Carson?
I was just going to say that, I mean, if we were trying to completely exactly match code with this, I mean, there's going to be other things that are going to come up, and I don't think it's necessarily relevant things. Like in this section A, that whole, though the code provisions relevant to in that list, I mean, that's not in code, but it makes sense to have it there because it is for our understanding. And the fact that we're a committee that regularly meets implies an ongoing. So, I mean, I feel like this is minutia that
We lost you, Carson.
I thought that having the purpose match made sense, but I think the rest is more like it makes sense for us to modify it so that it makes sense for our internal understanding. I mean, especially when it's not a fundamentally different thing.
Yeah, and this is Cara. Based on what Maureen just said, I don't see, in looking through the bylaws, I don't see anything that stands out that says specifically the code says, there's nothing that really, I mean, we've got like the different sections here, but it's all, it's bylaws. I don't see anything that says like the code says this specifically.
Actually, it does. And it's wrong.
Colleen, can you please raise your hand in the future?
I did.
You weren't called on. Colleen?
Yeah, it does say that in at least one place, and it's a miscitation. It's wrong. But I think we need to have, and we've always had, the exact wording of the code. And this was given to us, exactly wording of the code, by the city attorney in the draft that we're working from. And all I did was put in the code, and some of it's gotten changed. In C, we definitely can't have establish enforcement priorities because they specifically
let's stay with A, please. Let's
okay.
finish.
Well, my point was, and I've said this a couple of times, but apparently I blew it in how I phrased it. We state the code, and then we establish guidance for how we're going to fulfill our responsibilities and duties.
I don't have a problem with us saying that we want to do an ongoing review in addition to comprehensive. I don't think that that's material. And we liked the fact that we said that it would be a continual process versus just a point in time.
Okay, that's up to the committee.
So again, it had been recommended that we add the ongoing component by one of the, I'd have to go back through all of our notes to see who recommended that, but we agreed at our last meeting that we wanted to include that. So I'm not hearing a reason why we can't include it. And other than the fact that it doesn't match code, but it's not going to match code because this is our bylaws.
So it doesn't matter.
Pardon me?
Oh, so it does.
What's that?
So you're correct.
Okay, thank you.
You're correct.
All right, so I'm going to move on. Colleen, what were your further edits?
On C, that was specifically removed from our wording and our ability. The committee shall establish enforcement priorities for code enforcement. That sentence was removed. And the other sentence that was removed was make recommendation to the city manager or his or her designee for adjustments to city staff. We were specifically denied that ability. So that has to be removed.
Yeah, the version I was given to edit didn't include that first sentence on C. It just started with seek input from.
Yeah, that's the code. The first sentence is something that isn't in code anymore, and we were specifically denied that. And the third sentence also was the original language that we were, was taken out of the code.
Okay, so this sentence will come out, is that correct?
Yes, and the third sentence will come out. It starts make recommendations.
The third. Oh, yeah. Thank you for catching that. Right.
And
Sorry,
the
guys,
next,
hold on, please. I'm just trying to catch up with you. All right, go ahead.
the next one is in D, and it's the fourth sentence down where it says as needed. For service delivery is the language in the code, and I think it makes more sense.
So we're
Because-
missing the words for service delivery?
Right. As needed was specifically taken out. And I think it's better to have for service delivery, not as needed.
Okay. All right, guys.
Do you want me to move on to the code problems that I see in the missed citations, or do you want to discuss these two open items?
I think that we need to stick with the bylaws at this point.
Well, that's what you've got them in. You've got them under appointment of officers and adoption of general rules. I think we need a section head there. I believe in line it would be section 5. And just say general rules, section 5, general rules, instead of appointment of officers and adoption of general rules.
Can you point me to where you're referring to?
Page 9, under D, that we were just talking about.
Here?
No, right here, right, appointment of officers and adoption of general rules. We were just talking about D. That needs to be section 5, and I would just say title it general rules.
Got it. Thank you.
Now, did you want to talk about these two open items under that?
Yes. Were there any other up until the point with the part that we finished? That you caught?
Yeah, there's something under membership.
Okay.
I had made a revision note to put in per charter 8, Roman numeral 8, the city manager shall provide a recording secretary for each board and commission. And I wanted to add to that, whose duties are defined in section 9. We can either put it in as C and change one member of the city council shall serve as council liaison, and move that to D, or make it D underneath that.
And what was D supposed to be again?
Well, it's there as C. One member of city council shall serve as council liaison to the committee. I thought C should be under the city manager shall appoint one member of city staff to serve as the staff liaison and one member of the police department. That's exactly the wording that's in the code. but I wanted to add, because the charter takes precedence over any code. And the charter says, charter number Roman numeral 8, the city manager shall provide a recording secretary for each board and commission.
So where are you saying that again?
It's in the charter. And I had recommended that it be put in, and it didn't get in when I did my revisions.
Well, we didn't necessarily take everyone's edits, so that may have been something that, so I'm going back to the enabling legislation. To
The
try and
charter
find.
takes precedence, and we have all this language about recording secretary in the bylaws, but we have no recording secretary mentioned in the ordinance. But the ordinance, I mean, the charter takes precedence, and I think it's important to put it in there.
When you say the charter, what are you referring to?
The charter of the charter of the city of Inglewood, the home rule charter.
So
All ordinances
Maureen,
are
please,
subject
Maureen.
to the home rule charter.
Maureen?
So I think what Member Dickerson is saying is that the wording should be changed. Instead of it saying the city manager shall appoint one member of city staff to serve as the staff liaison, it should say shall serve as the recording secretary.
I want to cite the charter because the charter is important. It takes precedence over any ordinance.
That's what you're saying, correct? That there should be a recording secretary. Staff liaison can be changed to recording secretary because that's just wording.
That passage is exactly what the code, what the ordinance says.
Okay, so you want in addition a recording secretary? Is that what you're asking? Because I'm feeling that me being the staff liaison, I am the recording secretary. So maybe it could be / recording secretary.
Per charter.
Well, I don't know if you have to put per charter in there, but whatever you want to do.
I think it's important because the charter takes precedence over any ordinance.
I'm confused. So these are our bylaws, and it's up to us to decide what to put in there. And you keep saying that it must match the charter, but it mustn't match the charter.
Yeah,
Where-
plus our,
I didn't say it had to match the charter. I said the charter takes precedence over the ordinance, and the language there is exactly what the ordinance says.
And in all actuality, if I may,
Maureen?
that whole statement doesn't even have to be in there.
What whole statement doesn't have to be there?
B, you don't have to have B in there. But a quick and easy fix would just be staff liaison / recording secretary, because I'm pretty sure that's what I am.
Well, I would say you were appointed as recording secretary.
Okay.
it's
go
just,
ahead.
it's, I was just going to try to bring us back to, yeah, this is our own stuff. I mean, Ms. Willis is pointing that out. You, Chair Bowden, have said that. Member Dickerson, nobody's disputing that the charter rules and that the code rules after that. And this is just our internal bylaws, and none of us are confused by liaison being recording secretary. And if we need to put liaison / recording secretary to make, us be able to move on, great, but it doesn't appear to be necessary because we don't even have to have this language in our bylaws, since the bylaws are really extending from what the code sets up our ability to do. So, I mean, we could take all this out. We could, change it to whatever we want, it's okay. My only point on matching language was just purpose, because it seemed like if we're going to start our bylaw documentation, why not have it start with the purpose as stated in code? But beyond that, I don't see matching needs, since we know that the code and the charter rule.
Well, if you don't think we're going to run into any trouble, I mean, they wrote that for a reason. And the city attorney, when she did her original draft to us, did have the exact amount of the code, the exact wording of the code as it existed at that time.
Well, the code right now says staff liaison, not recording secretary.
Yeah, but it's in conflict with the charter. That's why I wanted to make it clear. If you want to take the entire thing out and just say the city manager shall appoint one staff liaison / recording secretary and one police liaison, that's fine with me.
Well, I keep putting it back to us, what makes sense for us. I think it's helpful to understand who is on the committee and what role they play. So I find it helpful to see it here. I don't go to the charter to understand I wasn't aware of that, but if I'm not opposed to having this in there and clarifying who's on the committee and what their roles are. Does anyone else have any other ideas, thoughts?
You mean you
Carson?
want to have the charter language in there? Is that what you're saying?
Well, we're just talking about adding the words / recording secretary after the word staff liaison. Carson, did you raise your hand?
Oh, I was just going to say, I think that's great, Chair Bowden.
All right.
I think we should do that too.
All right.
I think we should as well.
All right. Okay.
Simplification, I think, is good.
Yeah, I think it's helpful to know, to have that in there. And I'm going to scroll back up. One of the items that we had added and we decided to postpone it until the next time we met was, and again, like Colleen said, this is general rules, is community inquiries. And this refers to the need or the idea of having the Code Enforcement Advisory Committee be a resource for the community when they post questions online in social media. And I think most specifically, we're talking about Nextdoor. Right now, if someone has a question about code, we don't, as a unit, respond to that. What happens is people in the community issue an answer, and they may or may not be on point. I don't review everything, but the idea here is do we want to initiate an effort to be more responsive to questions from the community on code?
Well, it's part of our program, isn't it?
Colleen?
Yeah, isn't it part of our program? And it says we're supposed to develop educational programs for the community. So that could be part of our development program, how to respond to questions.
And we weren't going to actually decide what it was that we were going to do. We were going to put it into our list of priorities, because in order to establish a feedback mechanism for the community, we've got to figure out how we're going to do that. And it's a little more detailed, and it's a process that, and we want to make sure that we're also in line with code. And so my suggestion is we leave it here, and then add it to our list of priorities that we want to discuss moving forward.
Well, there is a provision in our in the bylaws as they exist right now towards the end, where any member can propose an amendment to the bylaws at any time or at any meeting.
Okay, so this is more establishing a feedback mechanism with the community. So when someone posts a question on Nextdoor, we respond to them as a code enforcement advisory committee, giving them accurate information. And, you know, basically we're building a community awareness that this committee does exist and that we are here for the committee. So I think it is a general rule. I think that we should put it in our role that, you know, like Colleen suggested, that we are responsible for educating the committee. We just don't have the procedures in place to get it done, and we don't know who's going to do it. So
you want to leave that an open item for now? And you want to leave it
and
there?
then right, and then way back in the day, here's our priorities in terms of, you know, what we would be working on next, and we would add this to our list. So actually, why don't we do this? Instead of working on it as a priority, you know, voting on where it belongs as a priority, let's postpone that to our next meeting and decide where we want to place that in our list, our priority list. Are you guys okay with that? Otherwise, we step out of the bylaws, we go back to our list of priorities, reprioritize, and then come back.
This sounds good.
Okay. The next question was actually related to committee members representing themselves as committee members. And the suggestion was that in our handbook that it is already covered. And I was able to find that statement. And so what I did, and it was for city council. So I changed out the word city council and put committee member. So when a committee member is present as city council and addresses the city council on a matter, the member should take care to represent the viewpoint of CEAC as a whole and to avoid expressing his or her personal opinion unless clearly stated as such. When committee members communicate with the public, they must state that they are communicating as an individual as opposed to a committee member unless stating an established consensus of the committee. Colleen?
Yeah, I thought that was just a little bit, because, you know, we can go, as citizens, we can go and talk about any matter under the sun at city council. And I don't think, you know, we're not representing any committee at that point. And as we're an advisory committee, we don't really have a viewpoint, except that we are to go by code until we recommend changes to code. So I think the whole idea was to avoid committee members from trying to use their position as to give them greater authority on other subjects. And I think it could just be a simple thing to say, like, we are an advisory committee, and as such, we'd prefer you not to try to use your position as a greater authority. Because when I go and talk about a subject that's may be related at some point to something that the committee may take up at some point, I am speaking as an individual, and I'm not saying I'm a member of the committee and therefore my opinion should hold more weight. I'm just expressing my opinion about code and what's happening. And I don't think it's necessary that I should be constrained to present some viewpoint of the committee I'm on.
Carson, you raised your hand.
Yeah, I don't think there should be any limitation, and there isn't. I think it's completely reasonable that when you're speaking to someone you don't know or to city council, that you be clear whether you're representing something that you were sent by this committee that we all agree we want presented a certain way, which would be the only situation where you'd actually be representing the committee. And otherwise, I don't think it's too much of a hassle to have to say, I'm not representing the committee. I mean, if I talk to someone, like in the case of, I saw something on Nextdoor and I communicated with someone, first thing I said was, I'm not representing a committee, even though I'm on one. I'm just someone who cares about what you're saying. And I don't think that that's unreasonable. I think that's fair.
I don't think it's necessary, because I don't make a point of being on the committee. If somebody asks me or says something negative about it, I just say, well, here's the code. I'll give them the citation, look it up for yourself. And if you want to complain, a CEAC committee meets on such and such a date, and you're welcome to show up for the public forum. But I don't make a point of saying, well, this is my personal opinion.
Yeah, and I don't think we're saying anybody does. These are general rules, and it's the conduct that as a committee member, you're seeing in the public and in front of city council. They know who you are. And so if you're speaking as an individual, I think it's fair for us to ask you to clarify that you're speaking as an individual versus a committee member. On the other hand, I have presented to city council on behalf of the committee, and I represented myself as a committee member, not an individual. So I think it's important that we have this clarification, and I don't see anybody violating this right now. I think everybody's been very good at clarifying, their intent, but I think it's important that we, especially moving forward, everyone understands the limits of their role. Colleen?
Yeah, well then I would suggest that we clarify the first sentence. When a committee member is present at a city council meeting and addresses the city council on a matter relating to ongoing behavior, relating to the committee, then should take care to present as an individual or as a committee member if they've been, if they're not speaking on behalf of the committee unless we have asked them to. Nobody should, but there's very few things except for our enabling legislation where we would be talking on a matter that relates to the committee. Just because the committee has the duty of comprehensively reviewing certain code titles does not mean that they are speaking on behalf of the committee when you go before council and talk about something that may or may not be related to something that the committee may or may not ever take up. So if we're present at city council to express on behalf of the committee, then we take care to only express what the consensus is of the committee on that particular subject. But I think this is just a little too broad.
So the wording was taken from our the committee handbook, and and then I modified it to be specific for this committee. So
you mean the council handbook?
Yes.
Okay. I'm not sure.
Is there anybody that objects to what we're saying here? And Colleen, I'm not hearing that you object to it. I just hear that you want to word it differently. And
yes, I think it's just a little too broad, and I don't know that we have a viewpoint of the committee as a whole in every case that I might be speaking on. So unless I am actually there to speak on behalf of the committee, then I have to stick to whatever the committee decided on the matter. But not just any matter, it's only matters that we have before council.
Yeah, maybe, I mean, I don't know if it's possible to word it this way, Chair Bowden, but just unless, maybe it should just be worded such that unless the committee has instructed you to represent the committee, then never state that you represent the committee, you know?
I think it says it. I don't have a problem with the way it's worded here. It's saying that if you are speaking as a committee member, then you state the established consensus of the committee. I think that's pretty clear.
Well, I like that wording, but I don't think that's when a committee member is present at a city council meeting and addresses the city council on a matter, that doesn't say a matter concerning the committee. That just is any matter, you know. So if you can just say what you just said,
the first one to me says that if you present to city council, you're either presenting your personal opinion or you're speaking on behalf of the committee. Either way, you have to state which one you're doing. Maureen?
This is a normal, average, everybody should use language. It's nothing out of the ordinary. I've seen this many, many times in bylaws. It's not unusual to have it worded exactly as it is.
I just don't see what's confusing about it.
I just want it to be more specific on a matter. If you're appearing before council on behalf of the committee, then you should stick to whatever viewpoint the committee has established. Either that or just say, whenever you speak, don't use your committee membership unless you are designated to be speaking on behalf of the committee.
No, I think it's saying that when you speak to city council, regardless of what you're speaking of, you identify who you're speaking as. Are you speaking on behalf of the committee or are you speaking as an individual? And that's what we're asking you to do.
I don't think that I didn't give up any of my rights to become a member of the committee. And I think that's kind of asking me to establish something that is unnecessary to establish. I don't think it's any matter, just if it's a matter, if I've been asked to speak for the committee, then I must identify that and present the committee's findings. But if I'm going and speaking about tap fees, I don't think I should have to say, I'm speaking as an individual, not as a committee member.
I think it's pretty clear. I need other committee members to speak up on this, please.
It
Hi,
seems clear to
Julie.
me.
Yes, I can't tell who's speaking. Is that Cara?
It was, but I think somebody else started if you want to go ahead.
No, you can go first.
So this is Cara. I was just going to say, Julie, I agree. I think the language is very clear. And I think, you know, with us volunteering to be on the committee, we have a duty to distinguish whether you are representing yourself as an individual or for the committee. So I think, you know, whether you like it or not, nobody is asking you to give up any of your rights, but being on the committee, I think you have a duty to distinguish who you're speaking as.
Thank you, Cara. Sonia?
I completely agree with what Cara has to say, and I think it makes sense to me. I don't feel like it's taking away any of our freedoms,
Okay.
our liberties. I think it makes sense.
Okay. Carson?
I agree with what member Frangipani. I've only heard it once, so I'm trying to get it right.
Good job.
So yeah, I agree with that. I have no problem with stating that I'm representing myself if I do choose to go in front of city council. I'm on a couple committees, and I think it's reasonable. A citizen might know that I'm on those committees and might wonder if I represent them, and it's no skin off my back to just say I'm speaking individually.
Okay.
Chair Bowden, can you see me on your screen, or can you see that my hand is raised?
Now I can. I could not see you before.
Oh, okay, because I've been trying to just.
Oh my gosh. Okay. No, I did not see you. Now you're okay. I've got to resize this window. That's what's going on.
Okay.
Sorry, Monica, I missed you. I fixed it, and now I can see everybody.
Okay. I just wanted to concur with everyone who just spoke. And I also think it lends some credibility to whatever you're saying when you're speaking, even if it's your own personal opinion, to, people know that you're invested in the community and that you've taken some time to learn about these things if they do pertain to code, even if it's your own opinion on it and maybe not something that the city council has adopted so far. And I really don't think it's infringing on any rights.
Okay.
That's all.
All right. So we're going to move forward from there. Colleen, did you have any other edits from our June conversation?
Yeah, a couple. Just to clarify some things, under where you said review ended, resume here.
Yes.
Most of this language under term and vacancies is in the code, but what isn't is in accordance with Article 2, Chapter 13, members appointed to vacancies will serve out the remainder of the vacancy or 2 years, whichever is shorter. Article 2, Chapter 13 does not exist. I would propose, because these are short things, to combine terms and vacancies and put Article 2-10-3. Go ahead and put in members will be appointed to overlapping terms of 2 years. The city council shall make appointments to fill vacancies for unexpired terms. Cross out in accordance with Article 2, Chapter 13. And then say members appointed to vacancies will serve out the remainder of the vacancy or 2 years, whichever is shorter.
Okay, so I want to make sure that I've captured this correctly. So you're proposing that term and vacancies be combined into one paragraph?
And cite Article 2-10-3 because that's where the language is. But the language about members appointed to vacancies will serve out the remainder of the vacancy or 2 years, whichever is shorter, is not in there. But if you want that in there, it's no skin off of my nose, but it isn't in Article 2-10-3. So I don't know if you want it there or not, or just say this is part of our bylaws, or I don't know how you want to do it. But if you cite Article 2-10-3, that particular statement that's after a it's a typo apparently, is not in that code. So maybe we don't, we just want to take code out altogether and just say that.
Okay, so it would be term and vacancies, members will be appointed to overlapping terms of 2 years. The city council should make appointments to fill vacancies for unexpired terms. Members appointed to vacancies will serve out the remainder of the vacancy or 2 years, whichever is shorter.
Yes, and don't cite the code because
Right.
half of that's not in the code.
Okay. Does anyone have any issues with that proposed change? Okay. So at this stage, we're back into all of our combined edits. And what I'm showing you here, just for the people that are new, we really did go through this in in-depth detail, and a lot of people had input into it. So yeah, we didn't have any comments beyond that. Okay. Moving forward, let's see.
The next one would be compensation.
Let's go ahead. Okay, vacancies. All right.
It just says the members of the committee shall serve without compensation, but the rest of the code, and I think it's reasonable to put it in, and it's in there in a certain way in the old code. It says reasonable expenses directly related to the duties are allowed. And I think that should be added.
Great. Can you say that again?
Shoot. Let me see where it is. Oh, I'm trying to work two computers at once. Okay. Under compensation, the members of the committee shall serve without compensation. Reasonable expenses directly related to performing the duties of the committee shall be allowed. It's under 2-10-4.
Maureen? Yes. Maureen?
Just a note that there is absolutely no budget for any advisory boards.
And we know that in the past when we did the what was it? The fair, not the fair, when we had the Inglewood
Block party.
Thank you, the block party. We did actually have expenses, and the code enforcement budget paid for our expenses. Colleen?
Yeah, previously we had wording in our bylaws that said we were allowed to raise money and obtain donations to function and pay ourselves back if we had expenses. It wasn't necessary, but it was there. So we don't have a budget now, but there is language further down about how to handle it if we do.
Okay, that is in there, right? That we can
Yeah.
raise. Okay,
I'm not
great.
sure it's quite what we want, but it is in there.
Okay. And unfortunately, this actually brings us to the end of our meeting, which we got up to compensation. So what we'll do is we'll go ahead and make the edits that we discussed today and pick up where we left off at our next meeting. We'll need to schedule our next meeting in September. Does the 23rd of September work for everybody?
Oh, it's pretty close. Yeah.
Anyone
I'm
have an
okay with
issue
it.
Okay,
It should be fine.
okay. And
At
then are
6
there-
o'clock again?
Yes, please. And then are there, in addition to, Carson?
Well, two things. Just on the scheduling, are we going to switch to always doing the fourth week instead of the third?
I think it's up to us. Do you want to go
Because
back
this
to
has
the
been
third?
what, now we've been doing that. This is like the third one
Yeah.
today, I think.
Yeah,
I don't have a problem with it. I'd rather be able to know
Yeah.
rather than each meeting have to wonder because of scheduling other things.
if we do the 16th, that's 3 weeks away. The 23rd is 4 weeks away, and we still have another week left in the month of September. Colleen?
Yeah, while we're doing the Zoom meetings, it's not a problem with scheduling rooms. And there is language in our bylaws about meetings
and it says ad hoc. And one of the things I was wanting to consider as a committee, do we want to change that since we have been meeting every month for several years? Say that we're going to switch to another time or date, or that it's up to us at every meeting to decide when the next meeting is going to be. But right now, you can schedule a meeting anytime you want, as long as we have 3 days notice.
Yeah, but I don't know that that's very practical, especially considering we have a city council member and staff liaison to coordinate as well.
Yeah, but it's in the bylaws right now, so that's something we want to consider.
I don't mind doing the third week every week and sticking to that. And then I think what happened is we had a meeting, a citywide meeting that superimposed over on our committee meeting. So we postponed it a week. So we can pull back and go back to the third week, which would be September 16th. I'm fine with that.
But it's not in our bylaws as yet.
Right. We can decide when we want to meet. So, okay, September 16th is our next meeting. And at this point, I'm going to call the meeting adjourned and thank everybody for their time and attention. And have a good rest of your evening.
Thank you, Julie.
Thank you.
Bye.
Good night.
Good night.
Bye.